The second bullet then says, as a result, the NSIA has asked PCO to begin work on mapping this. So how is intelligence circulated? How are ministers informed? How do they exercise their ministerial accountability? The governance, she says, seems to work well at the deputy level and even between PM and PMO, but that gap at the ministerial level may be a concern. So we discussed this a bit with the NSI at the time, Jody Thomas, and what she said about this, and the reference for the record is at WIT 151, paragraph 81. I won't bring it up, but I'll just tell you about it. The conversation around ministerial accountability was that in the NSI COP and NCERA reports, as well as the media leak discussions, everything needs to go to the PM. But in fact, in a Westminster style of government, ministers have accountabilities. So that was the nature of the discussion that was being had at this meeting. From your perspective, how does this play out? Was there an issue with ministerial accountability in the foreign interference space?
I think what you're outlining is sort of the second part of the conversation. The first part of the conversation is clear to me, and I can't really speak to what Jody was sort of digging into there. But it's very clear from the first bullet the gaps on how FI is handled in between elections. I think the important thing to remember is when we created the site task force, the panel of 5, it is because during an election, during the writ period, the government is in caretaker mode. So there actually are significant limits on how and whether ministers and the prime minister to continue to be ministers or prime ministers even during an election. But they are limited in what they can actually go out and say, particularly if they're about to say that an opposition party is compromised or benefiting from interference by a third country in an election context. That would be destabilizing and of concern to do. That's why we set up the panel of 5 top public servants to be able to address during a writ period and publicly speak to what a particular piece of foreign interference is trying to have as its impact on an election. That makes total sense as a structure during elections, but during a by-election, where we've actually made sure that the site looks in on that, you don't have a caretaker convention. During a by-election, the government continues to be the government. The Minister of Public Safety or Foreign Affairs or the Prime Minister continue to be fully empowered to do all their works. And therefore, it would be during a by-election if there was a significant concern that a particular country was engaging in massive misinformation, disinformation, it would normally be the minister who would do that, who would talk about that, be accountable for that communications and those actions. But because of the partisan nature of the event that is a by-election, there's a discussion on, well, whether that ministerial accountability should be there around that or whether officials should take on the communications, even though it's most clear moment in the G20 meeting in Indonesia, where I directly informed Prime Minister that he needed to make sure that China was ceased interfering into Canada and Canadian democracy. It wasn't a conversation that went particularly well, but it was a conversation that needed to be had and that we had. However, despite that and many other messages to China, the interference continued and even in some cases increased. So that was part of the reason why we needed to make sure there was a clear consequence. Secondly, as we looked into it, as allegations around Michael Chong were surfaced publicly on digging into it with the Foreign Affairs Minister here in Canada, it was clear that even though in the case of Michael Chong, Zhao Wei was not engaged in interference so much as influence, that is, regular diplomatic collection of information with the goal of sanctioning, for example. So in the case of Michael Chong, not direct interference in the analysis of our intelligence agencies, but in other cases have been involved in interference activities. We realized that was a reason to look at kicking him out of the country, that he was involved and known to be involved in foreign interference, even if it wasn't directly in the case of Michael Chong. And third, the fact that there needed to be consequences for China. He'd been involved in foreign interference activities. And third, it had been made public, meant that he was also not going to be able to operate as a regular diplomat in Canada anymore. His utility as a diplomat to both Canada and I guess to China ended because he was so clearly outed in the media as being a bad actor. Those three things together meant that to give consequences to China, to give consequences on foreign interference, and specifically the fact that he was not going to be much use as a diplomat anymore, we chose to kick him out of the country.
Okay. I'm going to move now.
Actually, I think we asked China to remove him from the country first, and when they didn't, we said, okay, well then we're going to have to kick him out.
Okay, so one last chance, and then he was gone. We'll move now to another event that led to the PNGing of a diplomat, this time an Indian diplomat, which is the murder of Hardeep Singh Nijjar. I'll ask the court registrar to pull up WIT 106, please. So there's a few things to talk about in this, and if we can scroll down to paragraphs 52 to 55, please. There we go. So the first question I'll ask you to take us through, Prime Minister, is what led to your announcement in the House of Commons in September 2023?
Over the course of the summer, I was apprised by my intelligence services that there was credible intelligence that agents of the government of India were involved in the killing of Hardeep Singh Nijjar. This is something that we had actually asked the intelligence agencies to look into because following the rather high-profile killing months before, the initial assessment was, oh, this was gang-related or criminal-related. There was not an obvious, immediate international nexus to this. And that's how we were briefed after the meeting, after the killing in the days afterwards. However, hearing directly from a number of our South Asian members of parliament and seeing and talking with members of the South Asian community around who were quite insistent that it was something that was likely connected to government of India. We actually asked the intelligence agencies, and it turned out they were doing this anyway, to look in more closely to the circumstances around this particular murder. So in late July, early August, I was briefed on the fact that there was intelligence from Canada and possibly from Five Eyes allies that made it fairly clear, incredibly clear, that India was involved in this killing. Agents of the government of India were involved in the killing of a Canadian on Canadian soil. This was something that we obviously had to take extremely extremely seriously. That violation of sovereignty, of the international rule of law, with extrajudicial killing in a foreign country, in a fellow democracy, was a massive mistake. If India had indeed done it, and we had reasons to believe that they had. So our immediate approach was to engage with the government of India to say, and we had our various security officials reach out to India and say, look, there are real concerns that your security agencies were involved in the killing of Nijjar. We need to work on this together because that can't stand. We need to make sure that there are changes and there's accountability for this process, but let's try and do it in a responsible way that doesn't come and blow up the relationship between Canada and India. And that was the attempts we made in the month of August. As we approached the end of August and September, the big thing that was happening was India was itself hosting the leader of the summit of the advanced economies of the world, the G20. So it was a big moment for India, welcoming the world, all the leaders of the world to Delhi for a very important summit. And we had the opportunity of making it a very uncomfortable summit for India if we went public with these allegations ahead of time. We chose not to. We chose to continue to work behind the scenes to try and get India to cooperate with us. Their asks of us was, well, how much do you know? Give us the evidence you have on this. And our response was, well, it's within your security agencies. You should be looking into how much they know. You should be engaging. It's, oh, no, tell us what you know. Show us the evidence. And at that point, it was primarily intelligence, not hard evidentiary proof. So we said, well, let's work together and look into your security services and maybe we can get that done. No, we're not doing that. It culminated with a conversation I had with Prime Minister Modi on after the end of the last session at the G20 in Delhi, where I sat down and shared that we knew that they were involved and expressed a real concern around it. He responded with the usual response from him, which is that we have people who are outspoken against the Indian government living in Canada that he would like to see arrested. And I tried to explain that freedom of speech and freedom of people who come to our country to be Canadians to criticize governments overseas is, or indeed to criticize the Canadian government, is a fundamental freedom of Canada. But as always, we would work with them on any evidence or any concerns they have around terrorism or incitement to hate or anything that is patently unacceptable in Canada. And we have taken action in the past. We continue to take action. Even as I emphasize, and I have emphasized regularly, my position and Canada's position is to defend the territorial integrity of India. One India is official Canadian policy. And the fact that there are a number of people in Canada who advocate otherwise does not make it Canadian policy, but also does not make it, is not something that is illegal in Canada. Having done all that, we returned to Canada, and it was obvious that the Indian government response, particularly through the media, was to instead attack Canada, to attack Canadians, to criticize us, to undermine our government and our governance, and quite frankly, the integrity of our democracy. Combined with the fact that as we approached the end of September, it looked like there was going to be media stories detailing some of these allegations that were getting out there. When on the first day that the House returned, we determined that it was in the interest of public safety in Canada to to let people know that we knew about these allegations, that we were following up on them. There was an investigation into them that was taken on by police services in Canada to ensure that, partially to ensure that nobody in Canada, in any communities, felt like they needed to take action themselves, that they should trust Canadian institutions to take this threat seriously and follow up on it. And that's exactly what we then did. We launched investigations. The Indian response to these allegations and to our investigations was to double down on attacks against this government, attacks against this government's integrity, attacks against Canada in general, but also to arbitrarily eject dozens of diplomats from Canada, from Canadian diplomats from India, on absolutely no cause other than to say, well, we don't like what you said in the House about us, and we're going to punish you for that. This was a situation in which we had clear, and certainly now even clearer, indications that India had violated Canada's sovereignty, and their response was to double down and attack Canada further, rather than take responsibility or say, how can we fix this? Yes, this was a violation of the rule of law, and even take any of the many off-ramps we offered, because we don't want to be in this situation of picking a fight with a significant trading partner with whom we have deep people-to-people ties and a long history, and our fellow democracies. But standing up unequivocally for Canadian sovereignty and for the safety of Canadians back then was essential, and absolutely led to the very, very clear pronouncements we made earlier this week that the RCMP, the conclusions and the evidence that the RCMP determined in terms of violence towards Canadians that has been enabled by and directed by, in many cases, the Indian government.
So you've made reference to the allegations that were the announcement of the RCMP earlier this week, and we know that that wasn't solely connected to the Nijjar investigation per se. It's a broader thing than that, and it involves allegations of interference by India in promotion of violent extremism, tying agents of the government of India to homicides, violent acts, the use of organized crime, and interference into democratic processes. So it's a much wider thing. And we know that it led to, over the past weekend, the PNGing of 6 Indian diplomats. What can you say? And you mentioned before that the hope was not to blow up the relationship with India after the Nijjar murder. Obviously, things have progressed since then. What comment are you able to offer on what the RCMP announced on Monday and where things stand at the moment?
The decision by the RCMP to go forward with that announcement was entirely anchored in public safety and a goal of disrupting the chain of activities that was resulting in drive-by shootings, home invasions, and violent extortion, and even murder in and across Canada, particularly in the South Asian community. Largely Sikh, but not exclusively the Sikh community. The goal of disrupting the chain that was diplomats collecting information on Canadians who are opponents or in disagreement with the Modi government, passing along that information to the highest levels within the Indian government, and then having that information directed through criminal organizations like the Lawrence Bishnoi gang to then result in violence against Canadians on the ground. It was the RCMP's determination that that chain or that sequence or that scheme needed to be disrupted, and going public on Monday as they did, and removing those diplomats. The first option was actually being able to question those diplomats and interview those diplomats by having them waive diplomatic immunity. They didn't. That's not surprising that they didn't. Canada wouldn't waive diplomatic immunity in many cases either. But therefore, we had to ask them to leave the country.
Okay. And just to be clear, when you speak of diplomats collecting information in this instance, we're not talking about research and Google searches. We're talking about covert, clandestine.
Covert, clandestine, coercive measures, threatening to withhold family visas, paying sources, a range of things that the RCMP can detail if they feel they are. I mean, one of the important things on this is these are ongoing. There are ongoing court cases and trials. So if the RCMP had its druthers, it wouldn't have revealed any of this. It's just that it hit the threshold before it came out naturally in court through our judicial process, as it would, as much of this will. But the threat to public safety and the need to disrupt preemptively, even before the court cases were fully adjudicated, made it the RCMP's decision to go public with this.
Okay. Well, as you mentioned, there are ongoing investigations, and in that sense, I think we've probably gone as far as we can go on that topic, so we'll move on. We can take the Nijjar document down now. Going back to the chain of events, I think that we can say followed the May 2023 media leaks and the revelation of the PRC interest in Michael Chong. One thing that we know happened was that Minister Mendicino issued a ministerial directive on threats to the security of Canada directed at parliamentarians. And when we spoke about that initiative in camera, you expressed some ambivalence towards the policy. Now, I'm wondering if you can tell us about that.
I have very little doubt that had there been genuine threats, or there had been deliberate threats direct threats, or the word that ceases use, direct threats to Michael Chong or his family, that information would have been elevated to at least the Minister of Public Safety, if not directly to my office, on threats to a parliamentarian. But in the messiness of having a criminal leak erroneous information to the media and the attention and worries that ensued, I asked Minister Mendicino to put out a clear directive that said if there's any threats to parliamentarians or their families, that should be automatically elevated, regardless of whether they are credible or single source or reliable or unreliable or not. We need to elevate the attention that is given to parliamentarians' safety. I don't know that it's entirely necessary, if I'm being honest. I have confidence that if there is a threat to a parliamentarian, CSIS and our SIA and our security apparatus would take it very seriously and make sure there was awareness and follow-up on it. But in the moment, and to show Canadians how seriously we were taking this very serious issue, emitting this directive that said, yes, explicitly you have to do it, was a responsible step. I prefer to demonstrate confidence in the decision-making frame of intelligence agencies around how they elevate and how they evaluate information as, okay, this is really credible, we need to see this. This is not so credible, but let's let the local police of jurisdiction or let the RCMP know about this. Like, they make determinations around where information should go and what should be done with it every day, all the time, on a whole bunch of different information. And being overly prescriptive is not the ideal way of doing things. But in this case, I think it was a fine thing to do.
Okay, that's fair. The next thing I want to ask about then is providing classified information to that foreign interest to party leaders, leaders of political parties or cleared representatives of political parties, as the case may be. The first question I'll ask is fairly general, but when you as a party leader receive information about potential foreign interference happening within your own party, what can you do about it? What are the options available to you in such a scenario?
Oh, there are many, many things I can do. If it comes early enough in the process, I can simply disallow a candidate from running for a nomination or to be a candidate in my political party. And a party leader, all party leaders have ultimate discretion because Elections Canada requires that the party leader signs off on every single one of the 338 candidates they can run across the country in an election. And withholding that signature from a particular candidate is one of the core responsibilities, or that signature is a core responsibility and powers of a party leader. And it happened at an early enough stage that if someone expresses publicly that they want to run for the party and don't end up running for the party, there's not necessarily a scandal around them not running. There could be some sour grapes. There could be, I just had to decide to stick with, family was more important or anything. There's all sorts of face-saving ways in which if a leader quietly says, no, there have been concerns raised, you're not going to be able to run for us. But we don't need to talk about it publicly. You can go back to your life. That is an effective way of having things done that don't require revealing any classified information, but is based on intelligence that the leader can get. Once someone's an actual MP, a party leader cannot fire an MP. MPs elected by Canadians. All a party leader can do is, at the largest level, remove them from their party caucus, have them citizen indicted, something that I've done many times for a range of different reasons around sexual misconduct or other things. That's the biggest tool a party leader has. But there's also other tools. If there is an allegation around, to use the National Security and Intelligence Advisor's words herself, around inappropriate behavior or poor judgment or untrustworthiness, as a party leader, I can decide which committees an individual sits on, doesn't sit on, whether I give them a critic role or a parliamentary secretary role or even a minister's role. We have many tools to respond depending on the seriousness of the allegation. If it's that they're overly friendly with a particular consul general, maybe we just say, yeah, you know what, you need to clean that up, and then maybe we can revisit a committee or a parliamentary secretary role for you in a couple of years or a year if the thesis comes back and says, yeah, there's been no compact there. Like that. There's lots of tools that a party leader can exert to counter real or risks of foreign interference in their party. But it requires the leader to actually be able to receive the classified information from intelligence agencies to then turn around and take action on it.
Okay. On that topic, I'm going to ask you what happens when you receive intelligence about potential foreign interference having to do not with your own party, but with opposition parties. To do that, I'll ask the court registrar to pull up CAN 047007. So we'll just go through the document to situate a little bit, and I'll ask you to pull up a different one. So, Prime Minister, this is a memo for you from your NSIA in May 2024. You'll see what it says at the beginning of that summary is intelligence details alleged foreign interference activities in Canada directed at opposition parties. Given the serious nature of the allegations, PCO is working with CSIS to develop top-secret level briefings for opposition parties on this intelligence, then speaks to various political parties and whether or not they have leaders who are security cleared, and then the last bullet there speaks to PCO sharing a protocol providing more regular classified briefings to recognize parties. If we can scroll down again, please, I'll tell you when to stop. Scroll through background, I think we want to get to page 3. There we go. PCO comment there. So PCO notes that the informing the party leaders could allow them to identify the issues, take any necessary action, and then says an ad hoc approach of sharing intelligence is not ideal, and we should maybe think of doing something more systematic. So if we can take that document down now and put up WIT 164, paragraph 25. This is the fully disposable version of the conversation that was had in camera about this. So we'll look it up as a reference point. I'll just ask you, Prime Minister, to take us through, from your recollection, what happened here, what the situation was, and what was done about it.
In paragraph 26, you mean?
Yes.
Yeah. I received, exclusive, certainly extremely lying information around foreign interference into a particular political party. And I directed CSIS to try and, or intelligence. Obviously, as you say, Russia's invasion of Ukraine, the pandemic itself, in terms of a destabilizing crisis for the global economy and for countries around the world, the rise of the tools around social media misinformation and disinformation that were present back in 2015, but not nearly as sophisticated or pervasive as they are now, have caused a lot of challenges. One of the other things is in 2015, as we watched the American impending election of Donald Trump and the rise of right-wing populism around the world, that seemed to be one of the big threats or big concerns that we had that was potentially destabilizing. Things like Brexit coming along, Donald Trump's election. There was a lift of right-wing populism. It was very much the moment we were living in 2015, 2016, 2017, and grappling with as a responsible, progressive, rule of law democracy that believes in facts and evidence as the basis for policy decisions, as we are as a government. But over the subsequent years, it is not just about sort of right-wing populism that is still there. There is a significant rise of authoritarianism and an aggressive decline of democracy and democratic values in many corners of the world that are aggressively attempting to destabilize mature democracies, where populism can sometimes sort of twist the rules and the emphasis and, twist the facts a little bit for its own gain. The attacks on the cores of our democracy and our institutions that the authoritarian narratives and attempts at disinformation and propaganda and sowing chaos in our democracies are much more serious and severe over these past years than they have been. We need only to look at the headlines this week to see the extent of interference activities and the impact they have on Canadians. But we've seen that with a rise of a more authoritarian China and the arbitrary detention of two Michaels. We've seen that through the complete rejection of the UN Charter and the rules-based order by Ukraine's being invaded by an authoritarian Russia. The world is more uncertain and less safe than it ever has been, and the answer that Canada needs to give is to double down on the rule of law and on the international rules-based order that protects us all. We cannot allow might to become right once again in the world. I mean, we have the multilateral rules-based order as a protection against that, and the fact that Russia in particular has chosen to upend that, along with other countries, is something that Canada must stand unequivocally and strongly against, because it protects us, but it also protects countries around the world.
Well, as you say, the headlines this week also reflect that, and we'll come back to those as well. Before we break, I do want to talk about or begin the discussion on the development of the government's response to foreign interference in the face of all of this or earlier. And I'll start with talking about the HAS-MC, so the Memorandum Cabinet on Hostile Activities to State Actors. And I'll ask the court registrar to pull up here COM Sum 4, which is a summary of that MC. So this, we know, is a major cabinet initiative in the foreign interference space that has been discussed in the Commission's proceedings. If we can zoom out so that you can see the 4 bullet points, essentially. Next page, there we go. 1, 2, 3, 4. So we see a number of elements in the strategy here. One is the first broadly endorsement of the counter HASA strategy. The second is a strategic whole-of-government communications approach. The third is consultations on legislative tools, the CSIS Act, Criminal Code, and the Security of Information Act. And the fourth is new capabilities for the RCMP. So in all of this, we know that parts of this at least eventually became the legislation that we know fondly as Bill C-70, which was introduced into Parliament in spring of 2023 and recently passed into law in, I believe, June 2024. So first question I want to ask is what happened in that 2-year interval? So the HAS-MC being ratified in June 2022 and Bill C-70 coming into law in June 2024. It took 2 years for that to develop. Can you explain why that happened, and did it happen quickly enough?
It absolutely happened in the time it needed to happen. Anytime you are giving more powers to security agencies to counter, in this case, hostile actions by state actors, or anytime in general you're giving more powers to security agencies to do new things, to counter new threats, you have to be very, very careful about the balance you get on protecting citizens' rights, protecting diaspora communities that could be affected, by protecting marginalized groups that have historical and systemic reasons to be worried about authorities having more powers to enforce, to police, to investigate on them. It is not a small thing to grant new powers to counter new threats to intelligence agencies. And that's why, in the process of C-70, there were multiple visits to cabinet over subsequent years. There were multiple rounds of consultations with different diaspora communities, with stakeholder groups, with human rights defenders and charter rights groups. We knew that getting a significant piece of legislation that would strengthen Canada's ability to protect itself from national security threats from other countries was something that was delicate and that needed to be done right. I mean, we had the example of Bill C-51 in the last years of the Harper government, where the balance wasn't gotten right. And we committed in that election that we would repair the balance on that, and we did rapidly after getting elected, and strengthened the balance to make sure that we were, even as we were granting new powers to intelligence agencies that were relevant and needed, the protections of fundamental rights of Canadians, and particularly of vulnerable groups, were strengthened in our measures that we took in the first years in office. So we had direct experience that getting this balance right is really important. As people may remember from the 2015 election, the NDP leader, Thomas Mulcair, made it a huge point of contention for him that the violation of charter rights within Bill C-51 were fundamentally so egregious that it was terrible, not just that Stephen Harper put those forward, but that myself and the Liberal Party would actually say, no, we're going to accept those improvements, but we're going to fix them as soon as we get elected, which we ended up doing. We chose to not play politics with issues of national security, and we said it's not what we would do, and we will change it if and when we get elected. But that experience deeply informed our approach to building C-70. And I think that the result of the work that we did with C-70, the fact that it passed through the House with broad support and the Senate with broad support and is now in place and active without significant outcry by minority communities or concerned groups, shows that we did do the work to get it right. And getting this right and building consensus around these issues was a fundamental goal of this government. And quite frankly, when C-70 passed, there was criticism that we'd moved too quickly on it. As you highlight, there's also criticism that maybe we took too long for it. Doesn't always work this way, but in this case, I can say that it probably means that we took about the right amount of time to get it right, certainly because it was passed and is generally seen as, by all parties, as an effective and important piece of legislation.
So, Madame la Commissaire, est-ce que vous voulez ajouter quelque chose?
Madam Commissioner, do you want to add something? No, I'm okay, just listening. If you have any more questions before the break, that's okay.
Prime Minister, the second question I want to ask on that is it enough? One of the Bill C-70 obviously countering foreign interference, countering hostile activities of straight actors is an even broader term. But one of the criticisms we've heard is that the government has not done enough in this space and has not done enough to counter what is now a recognized threat. How would you respond to that?
Well, I think, first of all, I mean, I'd heard that criticism as well, or the frame that, well, since you had to, do C-70, obviously there was a mistake in the powers that CSIS or intelligence agencies didn't have before. You're correcting a mistake or an error or a shortcoming that existed before you corrected it. And I think that's the wrong way of looking at it. I think we are in a situation where the threats are constantly evolving, whether it's newer technologies, the advent of AI, the shifting and pervasive impact of social media in how people collect their news and understand the world around them, and the vulnerability to foreign interference and misinformation and disinformation that comes through that vector that wasn't the case even 10 years ago. The shifting geopolitics, where you have more assertive authoritarianisms, countries like Russia willing to invade a neighbor on the flimsiest of justifications, means that the world is changing in very real and dangerous ways that require us to step up. And at no point would I say that C-70 is enough and we can now sit back and coast on this for the next few decades because there will be no need to adjust and add more. That would simply be irresponsible. There is always going to be more work to do on ensuring that our agencies have the necessary tools to keep Canadians safe, while at the same time protecting the freedoms and rights of everyone in this country. And that is the constant, rigorous, responsible work that a government needs to do, to constantly be questioning, well, what more can we do to keep Canadians safe given these new threats, given these new challenges? How is the best way to do it while upholding the democratic and fundamental values and freedoms that is important to Canada? That's a constant debate in which not just the government, but stakeholders, communities, and even opposition parties have, and all parliamentarians have, an essential role to play in. It shouldn't be about partisan disagreements, whether, or a basis for partisan attacks when it comes to the question of protecting Canada's citizens, its institutions, and its sovereignty. And the kinds of debates we were able to have around C-70 and the kind of consensus that we had around getting it passed indicates that, to a certain extent at least, there is an understanding amongst parliamentarians that we shouldn't be politicizing or overly partisan in our approach on these issues of fundamental safety. We need to challenge, we need to make sure we're getting the balance right, and that different parties coming from different perspectives with substantive challenges to it is a really important piece of it. But my expectation is that there will pretty much always be, through the life of any parliament or over the coming decades, there will always be some sort of tweak or improvement or adjustment to our national security infrastructure that is being debated or looked at or legislated on or studied or reflected on an ongoing basis. Keeping Canadians safe is not a one-day job. It's a constant, regularly updated, foundational priority for every government every single day. And it'll come together in certain pieces of legislation, but there's always going to be more to do, and that is the work that government continues to do.
C'est peut-être un bon moment pour
This might be a good time for the break. Okay, so we'll take a 20-minute break and we'll be back at 11.
Order, please. Alors, s'il vous plaît. The sitting of the commission is now in recess until 11 a.m. Cette séance de la commission est maintenant suspendue jusqu'à 11 heures.
Ministerial accountability. The governance, she says, seems to work well at the deputy level and even between PM and PMO, but that gap at the ministerial level may be a concern. So we discussed this a bit with the NSI at the time, Jody Thomas, and what she said about this, and the reference for the record is at WIT 151, paragraph 81. I won't bring it up, but I'll just tell you about it. The conversation around ministerial accountability was that in the NSI COP and NCERA reports, as well as the media leak discussions, everything needs to go to the PM. But in fact, in a Westminster style of government, ministers have accountabilities. So that was the nature of the discussion that was being had at this meeting. From your perspective, how does this play out? Was there an issue with ministerial accountability in the foreign interference space?
I think what you're outlining is sort of the second part of the conversation. The first part of the conversation is clear to me, and I can't really speak to what Jody was sort of digging into there. But it's very clear from the first bullet the gaps on how FI is handled in between elections. I think the important thing to remember is when we created the site task force, the panel of 5, it is because during an election, during the writ period, the government is in caretaker mode. So there actually are significant limits on how and whether ministers and the prime minister to continue to be ministers or prime ministers even during an election. But they are limited in what they can actually go out and say, particularly if they're about to say that an opposition party is compromised or benefiting from interference by a third country in an election context. That would be destabilizing and you know of concern to do. That's why we set up the panel of 5 top public servants to be able to address during a writ period and publicly speak to what a particular piece of foreign interference is trying to have as its impact on an election. That makes total sense as a structure during elections, but during a by-election, where we've actually made sure that the site looks in on that, you don't have a caretaker convention. During a by-election, the government continues to be the government. Clear that India was involved in this killing. Agents of the government of India were involved in the killing of a Canadian on Canadian soil. This was something that we obviously had to take extremely seriously. That violation of sovereignty, of the international rule of law, with extrajudicial killing in a foreign country, in a fellow democracy, was a massive mistake if India had indeed done it, and we had reasons to believe that they had. So our immediate approach was to engage with the government of India to say, and we had so in a foreign country, let's try and do it in a responsible way that doesn't come and blow up the relationship between Canada and India. And that was the attempts we made in the month of August. As we approached the end of August and September, the big thing that was happening was India was itself hosting the leader of the summit of the advanced economies of the world, the G20. So it was a big moment for India, welcoming the world, all the leaders of the world to Delhi for a very important summit. And we had the opportunity of making it a very uncomfortable summit for India if we went public with these allegations ahead of time. We chose not to. We chose to continue to work behind the scenes to try and get India to cooperate with us. Their asks of us was, well, how much do